mediation is like arbitration, a form of out of court settlement or resolution of the dispute. It's collectively called ADR, which is alternative dispute resolution. The idea here is that instead of going through the whole rigmarole of court proceedings and litigation and basically incurring great cost, and it's not very time efficient manner, it can take years and years for a litigation to conclude. Mediation can be a more informal way of resolving your dispute with the other side. Now, in India, mediation in more recent times has been talked about, and there's a debate about whether you need a separate law which sort of codifies the process of mediation, etc. But mediation is something not new to India or the Asian region as a whole. In fact, in China, India, and all these countries, prior to the colonial systems of justice dispensation, our formats were inherently in the nature of mediation, where basically a senior of the village or a designated authority by the king or the ruler or that governing officer will be responsible for bringing parties together and ensuring a peaceful and amicable resolution of their disputes, being fair to both sides, and fairness in the sense that both sides are agreeable to the end result that is emerging out of it. And that is the principle that lies at the core of any mediation process. In more recent times, when you talk about the current laws, CPC, that is the Civil Procedure Code, under Section 89 talks about court annexed or court initiated mediation. The idea here is basically that if there is a civil case, again, this is only there for the civil cases and not for criminal cases because the provision is coming out of a civil procedure code. But if a court feels at any point of trial or even in an appeal stage that the dispute essentially can be resolved more amicably between the parties, and if the parties show some kind of willingness to talk about it outside of litigation, then the court can essentially issue a notification, an order appointing a mediator for the parties. Now, the mediator in this case is not really required to suggest solutions. The idea is that he or she will be a neutral negotiator that is bringing the parties to the table and ensuring that the parties can have an open dialogue. And that is at the heart of these proceedings, that you need to create that good faith that may have been lost through adversarial processes. In more recent times, there have also been certain legislations which are now talking about creating mediation frameworks. Most recently, the Commercial Courts Act that was enacted by the NDA government in its first term was amended in 2018 to provide for something called pre-trial mediation. Now, this is a unique thing because it puts a responsibility on the parties to actually attempt mediation before they even come to court. So that is unique. So essentially, if I have to go to court, there is an inherent responsibility of me to at least give a shot to mediation. This was brought about with the idea that this will make a lot of these commercial disputes, which are often between parties, like unless they're like really high profile cases which require some kind of adversarial litigation, they can be resolved in a more expeditious manner and at lesser cost if the parties can just internally agree to certain contractual obligations and rights for each other. And outside of these statutory frameworks, you can still have private mediation. So outside of these court annexed mediations that I've talked about, there is also the idea that parties may still want to actually just mediate even if they don't want the court to intervene. And not every kind of like the Commercial Court Act actually talks about pre-trial mediation specifically now, but not every other law provides for it. So in these circumstances, parties can still mediate. The idea of mediation is that at the day's end, I have appointed, or we have mutually appointed, a third person to sit as a mediator while we talk and try to resolve our disputes. Once those disputes have been resolved, you can create a contract which encapsulates the terms and agreements of your dispute resolution, and that will basically be governed by standard principles and rules of the Contract Act of 1872, which is how you can utilize it. Like, it's a binding contract between two parties. Court annexed mediations have a special provision though. if once the court has referred parties to mediation and that actually culminates in a fruitful sort of resolution where parties have agreed to how they want to end their disputes amicably, then those ideas can be put down into a document by the mediator, which will then be passed on to the presiding judge, and the judge will essentially pass a final order in the case saying that parties have agreed to these XYZ terms and conditions, and these are the rights and obligations emerging out of this sort of mediated resolution. And then a decree, like I talked about in your general course of a civil trial, a decree will be created to that effect, and that will be executed, and that essentially binds the parties. So it is a perfectly legal recourse to have. If anybody tells you that mediation in any sense is not possible, that is not true, at least for civil cases. In criminal cases, there are some exceptions where grave crimes cannot be mediated. And the last thing that I want to talk about is that now more and more high courts are basically creating in-house mediation centers, which are essentially these designated bodies which impanel senior lawyers and advocates and sometimes even retired judges or sitting judges to be part of the mediation panel. And these people are essentially trained in the law, and also the idea is that they have a clear understanding of what the law can be and how it needs to be read. So they are more fluent in the mediation process, and these are more structured institutions which can allow parties to mediate their disputes.